Before we begin and take up this particular agenda item, I wanted to make a few remarks and ask also Martin if he cares to make a few remarks before we introduce the panel. And I wanted to say this because this is an important three-branch solution. It's a three-branch solution to our pretrial detention program. As many of you know, SB 10 was signed into law on August 28, 2018. It goes into effect, as you've heard, October 1st, 2019. And as you've heard and are aware, the new law fundamentally changes our pretrial release and detention system. It is a paradigm shift from where the state has been. It transforms, in my opinion, an outdated, unfair, and unsafe system into one that not only effectively protects the due process rights of the accused, but also public safety. In a few moments, we will hear from those within our branch who have been engaged with this important issue for a long time. I raised my concern about bail penalizing the poor for being poor back in 2016 in my State of the Judiciary address to a joint session of the legislature. But 2 years before that, in the history of our council, we were already working with local courts and justice system partners using funds that had been provided by the legislature to create and administer 12 court pretrial release programs. And from those programs, those incubator programs, we gained practical experience. We learned about the impacts on recidivism and of supervised release. As you know, we tested models and the possibilities that these programs offered to improve our system and to provide justice for all Californians. The valuable real-life experiences and information gained from these programs informed the work of the Pretrial Detention Reform Work Group I appointed, ably co-chaired by San Diego Judge Lisa Rodriquez, who's here today, welcome, and now retired Ventura Judge Brian Back. This diverse group of jurists and one court executive officers studied the system. They listened to all interested stakeholders. They heard from more than 40 groups, civil rights advocates, state and national experts, justice system partners, government agencies, bail industry representatives, regulators, and victim rights advocates. They reviewed the input, discussed the issues, deliberated, and then unanimously reached the conclusion that then became the recommendations in their report. Quote from the report, money bail fails to adequately address public safety and the profound negative impacts on those individuals who should not be detained before trial, end quote. Unsafe and unfair. And all three branches of our government had expressed what was now a renewed interest in working on a solution to the pressing issue, and the work group's recommendations provided a foundation to support the unified process of work that informed SB 10. Last year, Governor Brown, Senator Hertzberg, and Assemblymember Bonta and I, as you remember, issued a joint statement about working and continuing our efforts. And on August 28th, after vigorous debate in the Assembly on their floor and in the Senate on their floor, we were joined by Senate President Pro Tempore Tony Atkins and Assembly Speaker Anthony Rendon as the governor signed this transformative bill. And there were many from the branch who pulled a laboring oar. Judges Rodriguez and Back and the entire work group, including Scott Gordon, Judge Gordon, our council member here, and Shelley Curran and her team at the Judicial Council. And there were some that did a little bit of steering of the boat with a laboring oar, and that was our Administrative Director, Martin Hoshino. He's contributed to the drive for bail reform, not only in California, but also at the national level as part of a national work group. And while I may have mentioned it and set a course, convened and connected, the stakeholders, it was this group that came to the study and convinced others, thank you, Martin, that this is in the best interests of California and justice. So I thank you all. I turn this over to Martin for a few more words.
Thank you, Chief Justice members. I wanted to just take a moment before turning it over to the panel to put some context on the change itself and the framework and the approach to it. The Chief mentioned that this has been 2+ years marching toward this. And we tried to approach this that we had already accepted that the current bail system in California, it wasn't just a matter that it had to change, that it was in fact already changing, and it was changing through practice already. in many communities of California and across the country, that it was changing as a result of litigation, and it was also changing because there were various legislative proposals that were working through the system up to 2 years ago. And so we thought that there was a replacement that was certainly at hand, and we had to make choices among that particular replacement. And the choices in shorthand were an earlier version of SB 10, the bill that was successful in completing its course through the legislature and being signed by the governor. But that version was not complete. It didn't at that time have an identified funding source. And it was, in essence, we felt hard and a little bit unworkable, and as you'll hear from the presenters, kind of a set of changes and amendments that were bolted onto a bad foundation. The second choice was to allow the litigation to keep running its course, and as decision by decision came down, to try and implement and change system almost maybe perhaps on an ad hoc or what can be described as a piecemeal basis as different decisions came down from our courts, and we would continue to adjust and work our way through those. And then ultimately the 2018 version, which you were about to hear about in terms of SB 10, which clearly is a version that comes to us with judicial input and the benefit of what the presenters will describe to you of our pretrial detention work group. It also comes with some delayed and reasonable implementation dates, and it comes to us with an identified funding mechanism, and it also comes to us as a byproduct of a compromise among all three branches of government. So this version of SB 10, which you'll hear about, really merges and we believe retains the valuable and workable principles and components of the earlier version, as well as following the blueprint of the pretrial detention work group put together by our judicial officers and one of our CEOs. And we think at the end of the day, it really does focus and balance the components of safety, fairness, and cost. But I do want to take a moment also to amplify the change in the reform in a way that seems a little lost, or at least a little less visible in the current heated rhetoric coming from both sides on this particular issue. And that is this, that in one significant respect, this version is really not bail reform per se. By eliminating money completely, it is a justice reform that corrects social, economic, and financial inequalities in our state. This is particularly important here in California, and particularly important now because California, as we know, has one of the highest poverty rates in the country, and it has one of the widest income inequality gaps in the country. So in one view, this is much more than bail reform. And in one view, it's really not criminal justice reform, but a plain and simple social change and correction that is long overdue. I want to also close with one word on the coverage and the reactions that are out there. There are a lot of concerns being expressed about what may happen with this change in the form of SB 10. The bail industry claims that too many dangerous people will be released. Some reformers, but not all, suggest that too many people will be detained. The truth is the bail bill cannot do both, and it actually does neither. What this new law does, in fact, is correct known inequities by treating people equally in a safe and fair manner. So instead of focusing so much as of late on what may happen with the change, I want to at least amplify something that we know will happen, which is this. No matter how much money you have, whether you are rich or whether you are poor, if you are arrested in California for a crime in the state of California, you will be treated the same. So with that, thank you for the privilege, Chief Justice and members, for introducing our panel. They are here after all of this long journey of multiple years, actually, to present to you and to impact for the first time for the council members in a public forum manner the elements and the path to getting to the bail reform as it stands in California today.
Welcome, Judge Couzens, welcome, Judge Rodriquez, and welcome, Shelley Curran.
Thank you. Good morning, and thank you, Chief Justice, Mr. Hoshino, and the council for having us here today. We're going to give sort of a historical perspective of how the work group came to their recommendations. Then Judge Couzens, our thankfully not really retired Judge Couzens, is going to talk about SB 10 and give sort of an overview and how that dovetails with the recommendations that the work group made. And then I'll turn it over to Shelley Curran, who is going to talk about the role of the Judicial Council in implementation, the funding, and how things are going to be implemented, as well as the time frame, and particularly focusing on education as well. So that's sort of what we're going to be talking about this morning. As I've mentioned, these are our presenters. Let's talk about the work group itself. About a year ago, I came before this council with my co-chair, Judge Back, and Brian McCabe, and we told you about our findings. We had spent about a year really taking a deep dive at the request of the chief into pretrial detention. And we looked at the history of bail. We looked at the current state of bail. We looked at other states and how they were doing it, the pending litigation nationwide. And this was a group, as the chief said, of 11 judges and 1 CEO. We were a really diverse group. We had quite a wide variety of backgrounds before we became judges. There were prosecutors, defense attorneys, former law enforcement, and civil litigators. We had judges that had decades of experience and some that had just a couple of years of experience. Large counties, small counties, and medium counties. And at the end of it, after hearing from 40 speakers and doing all of this research, we came to a consensus. And it was a consensus not just by us, but by all of the speakers that we heard from. Virtually everyone agreed that the system had to change, that it was not safe, it did not protect public safety, and it was not fair. And so knowing that, we sat down and thought about how would we recommend that we change it. And so you've seen the report. There's 10 recommendations. There are 10 recommendations that we believed needed to be implemented as a whole, that each one built on the last. And I'm going to highlight 4 of them for you today because these are all encompassed within SB 10. The first thing that we realized is that the current pretrial and release system based somebody's liberty solely on their available financial resources rather than on the risk they pose to public safety. What that meant is that if somebody didn't have money, they may not even have $5, and they could be charged with a petty theft, and they were not getting out of jail. But someone else who may have committed or was alleged to have committed a violent crime, if they had the resources available and a bail bond agent wanted to take their down payment, they could be released. No question about their public safety. Many times before they even made it to a judge, many times before a victim was heard on it. And so we had a system that was solely based on economics and not based on public safety, not a concern about whether they were coming back to court or not. It was how safe could they make that cash bail. And so our first recommendation, based on that understanding of the system, was that we needed to implement a robust, risk-based pretrial assessment and supervision system to replace the current money bail system. We just found that what we had was not working, and we needed to make it safer and fairer. The second thing that we came to was that judges often are making decisions at arraignment on bail without a lot of information. And when we want to make these decisions, we need information. We need information to decide who's more of a risk. We need information to fashion conditions and terms of pretrial release. And we needed that information so that we as judges could be making the decisions that we were compelled to make every day in court. And so we believe that one tool that we need as part of this decision-making process is a validated pretrial risk assessment tool. That does not mean that that takes over for the judge's discretion. This is not the final say-so. It's information to help us make those decisions. And we wanted it to be a validated tool, something that we knew had some science behind it. And so that is recommendation number 4. If a new system was going to be implemented, we felt very strongly that there had to be education, not just for the judges, but for staff, for the local justice system partners, and the community, so that everybody could understand, collaborate, and work together on implementing a new system. And we felt that that shouldn't just end after a system was implemented, that there should be continuing education, and we should be addressing both implicit and explicit bias in the system, in the new system, and in any assessment tools. And Shelley and Judge Couzens are both going to talk more about the education as well as the bias and how we are going to seek in any development to try to address those things. So we felt very strongly that we needed to develop a consistent and comprehensive education system that would be funded, it would be ongoing, and it would involve collaboration between all of the partners. And finally, and Mr. Hoshino touched on this, and that is, in reviewing everything, we knew SB 10 was going on, and we had looked at what was happening with SB 10. We developed our recommendation apart from that, but we thought about how to present a new system. And if we were going to do a new system, we needed to have something that had a solid foundation, that could be built upon to be sustainable and workable. So we really felt strongly that the system couldn't be grafted onto the existing system, that we didn't want to make the mistake of some of the things that we'd seen in the past that caused a lot of inconsistencies, a lot of litigation, where different pieces of the legislation don't work with what already exists, where there are those inconsistencies. And so if we're going to develop a whole new system without money bail, we recommended that we adopt a new framework of legislation and new rules of court to implement these recommendations. And so with that, I'm going to turn it over to Judge Couzens, who can talk about that new framework of legislation.
Chief Justice and members of the council, it's my pleasure to give you a first peek at the new legislation that we're going to be working with for some time. As Judge Rodriguez indicated, a lot of the work that's premised on this bill came from the PDR report that was prepared, and I think we were all delighted to see that the legislature embraced that report, made it a part of what they were considering, and you will see many of those things reflected in the legislation. It clearly informed the creation of that legislation. And as Mr. Hoshino indicated, some of the original concepts of SB 10 when it first came out were retained and looked at for over a period of 2 years and incorporated in it as well. And I think at the end of it, we saw very early on the use of risk assessment tools, the fast timeline for reviewing custody decisions, as well as the concept of preventive detention. These were part of the core principles originally, and they continue throughout the entire legislation. And now I think we have a bill that adequately maintains judicial discretion, gives judges the power to do what they need to do, and ensures due process for the offenders. I'm working on one of my infamous memos, and it'll go out sometime in October. Hopefully it will help kind of synthesize a little more specifically what's happening with this legislation as we start moving forward and creating the infrastructure necessary to implement it. But today I'm going to give you just kind of a quick overview. It's going to be like 32,000 feet at Mach 7, but it'll at least give you a sense of how these provisions relate to each other and really inform the process. It created a series of risk levels based on seriousness of the crime and person's record, and at each level, as we started moving through these levels, the bill gives greater scrutiny as the seriousness increases, and ultimately the decision to detain or not to detain will be based on an assessment of risk, not on money, as indicated by Mr. Hoshino. That was so important. We have eliminated in this bill does eliminate the use of cash bail, so that low-risk offenders are not going to be retained in custody because they simply can't afford the bail. But at the other end, the high-risk offenders are not going to get out of jail just because they can post bail and continue to be a risk to the public. The decision to detain or not detain will be based on an assessment tool, investigation by the pretrial services agencies, and ultimately an evidentiary hearing if necessary by a court. So due process is preserved. I think it's important to keep in mind that this bill is primarily focused on the first 48 to 72 hours of a criminal defendant's life. It's from that period of arrest to arraignment primarily. It can continue after that, but that's this very narrow period of time we're focusing on to try to infuse due process rights and protections so that we can retain only the people we really need to detain and release all the others. And it does take this money out of the equation. The first level are the misdemeanor cases. SB 10 makes the policy decision that most misdemeanor offenders will not be detained in custody. There are certain exceptions to that. There are 10 exceptions that are identified by the statute, but basically within 12 hours, misdemeanors are to be processed and released. And there is going to be no court review of that decision-making process. But we will have the ability to detain people where there is demonstrated violence, such as domestic violence and stalking and a few other serious crimes, so to protect the public, even though they are misdemeanors. The biggest work starts with the next level, when the felonies come into it. This provides for 2 levels of review. All felons will be assessed for risk, and the risk is simply this. What is the likelihood that they would commit a crime if released, and what is their likelihood of appearance later on? So looking at those 2 factors, everything is focused on those 2 factors. There's a risk assessment made, and that assessment will include a validated risk assessment score. A tool will be a part of it. There will be an investigation of the criminal history, their FTAs, the review, obviously, of the crime, input from the victim if available. They will make recommendations of release and basically consider any kind of information that's relevant to that release or detention decision. That decision needs to be made within 24 hours. The low-risk offenders will be released on their own recognizance. They can impose conditions if necessary, but this will be done without court review. It'll be done administratively by the pretrial release services. For the medium risk offenders, that's the low risk, so there's the first group. Now for the medium risk offenders, they also will be subject to a review process and potential release, but the mechanism of that is a little more complicated because the seriousness has gone up. What will be required of every county is to adopt a local rule, and that rule, based on that county's culture and the balance of the interests in that county, will define those people that can be released through this administrative process. There is a certain base will be provided by the statute or by state rule, but the county has certain discretion to make adjustments to detain more people. This is necessary, we think, to meet local culture. But this is the rule is mandatory, but how it's structured will be at the discretion of the court with guidance from the Judicial Council and a rule that we will write to help advise them. There is an optional provision which allows a local court itself to make release detention decisions. As you will see from the legislation, there is a group of crimes that are not eligible for release by the Pretrial Services Agency for the administrative process. But the court can provide review for those folks to make sure that they have an opportunity. If again, this is a local choice, they can authorize subordinate judicial officers to make that decision. The release standards will all be the same, whether it's the Pretrial Services Agency or the court. The release standards will be the same, but it does give a court, if it wishes to create an administrative structure within the court, an additional opportunity to have pre-arraignment review. Everything comes together at the arraignment. All charges, including all felony charges, will be subject to review at this point. This will include the high-risk defendants, defendants charged with serious and violent felonies, people pending trial on other matters. All of these things, all of these people will be subject to review. There is a presumption written into the statute that people at arraignment will be released, either on their OR or on supervised OR with conditions. That's the presumption, obviously a rebuttable presumption. The exception is if the DA files either at or after the arraignment a request for a preventive detention hearing. That triggers the final and most rigorous review of a person's status, because this will be the hearing or the process that decides whether that person remains in custody pending trial. The statute specifies those circumstances under which the DA may request a preventive detention hearing. It could be any crime committed with violence, or threatened violence, or with the use or arming with a deadly weapon or firearm, or a personal infliction of great bodily injury. It can be triggered with the fact that the person committed the crime while they were on some form of post-conviction supervision, like parole or probation, but not informal probation. It can be triggered by the fact that they were pending trial or sentencing in a felony case. It can be triggered by the fact they intimidated, dissuaded, or threatened a witness. Or it can be triggered by any substantial reason to believe that the conditions, that no reasonable conditions can be created that will adequately protect the public and assure the defendant's appearance at trial. So if one of those 5 factors exists, the DA can request a preventive detention hearing, and we move to the next level. The preventive detention hearing is conducted by a judicial officer. It has to occur within 3 days if the person's in custody. It has to occur within 5 days if the person is out. These are court days. They have a right to counsel. The victim gets involved. And most importantly, any findings are stated on the record. There is a process to winnow some of the contested hearings. There is going to be a rebuttable presumption that certain offenses will be subject to preventive detention, certain violent felonies committed with violence, and certain people assessed as high risk with certain other findings made. There will be a narrow group where a presumption exists. Otherwise, there is no presumption, and there will be an open hearing regarding whether the circumstances of detention are justified. The hearing itself, as you can see from the slide, is semi-formal, semi-informal. It can involve statements of the defendant and the victim. In fact, the defendant has a right, statutory right, to testify. It can contain offers of proof, argument of counsel, and any reliable hearsay. It's designed to be efficient and give both sides a full opportunity to present their viewpoint. And so it's this balance between the release and the detention issues. This is the all-important standard for detention. I apologize for the small words, but it goes this way. At the detention hearing, the court may order preventive detention of the defendant pending trial or other hearing only if the detention is permitted under the United States Constitution and under the California Constitution, and the court determines by clear and convincing evidence that no non-monetary condition or combination of conditions of pretrial supervision will reasonably assure public safety or the appearance of the defendant in court as required. The court shall state the reasons for ordering preventive detention on the record. So that's it. That's our ultimate standard. What's interesting about that standard is the reference to the California Constitution. As you know, not too long ago, a case in Ray Humphrey was decided by the First District, which raised a lot of constitutional issues. Along with that case, at about the same time, were 2 other courts of appeal decisions in Ray White and in Ray Webb that talked about certain aspects of our detention status and in our Constitution, and the Supreme Court has granted review of those decisions. And so obviously that decision is going to play an important role. In fact, they have asked for supplemental briefing on the effect of SB 10 on those issues. So this is going to be front and center in a very important decision that we will see that will guide us. So that is the standard of detention. One of the criticisms of some of the of use of these instruments, excuse me, I went too far, is the concern about bias, particularly about the use of the risk assessment instruments. And I wanted to address in my final comments just that particular issue. SB 10 addresses bias in about 3 different ways. First of all, the Judicial Council rules that will be developed are supposed to identify and mitigate any potential bias. It's perceived in these instruments, and obviously there's going to be a very cautious and deliberate selection of assessment instruments that have been thoroughly vetted and tested so that they are free of bias as best they possibly can be. The definition of the validated risk assessment specifically includes the fact that they shall minimize bias. And then finally, the legislation includes in 2004, a review by the State Board of Community Corrections to examine specifically the issues of bias as they relate to race, ethnicity, gender, and income level, to see if we're doing the job right, to see if these tools, in fact, are appropriately balancing these interests and not creating a problem of bias. So we hope that the structure of the bill itself will mitigate largely concerns about bias. And final comment I would say is that, as the Chief Justice mentioned, this is a huge change for a process for criminal defendants. But if you look at it, it's not much of a change for what judges do. We still, even now, we have to make release and detention decisions. We make that every day in our arraignment courts, and that's not going to change. It's going to happen again, but the big change now is that it's going to be informed, as Judge Rodriguez indicated. Up to now, we haven't had a lot of the tools we needed to make a really informed decision. We hope that this process through SB 10 will create a good fund of information so we can make good informed decisions about who is to be released and who is not. And we will have a clear record of that, so it's going to be exposed for public review and review by appellate courts if we tend to stray. So while it's certainly more transparent, it's what we do. We look forward to it. I think it's a great new era. It's going to be a challenge for all of us. The infrastructure will be daunting, but we hope in the final analysis that the objectives that the PDR report identified can be met through this legislation. I'd like to have Shelley Curran now speak to what this body is going to be involved with as we proceed through the next year.
Thank you. Good morning, Chief and members of the council. Judge Rodriguez spoke about the foundation and how we got here. Judge Couzens went into the details of the pretrial release and detention decision-making process, and I'm going to focus on some of the responsibilities that were specifically included in SB 10 for the Judicial Council, and then also some of the implementation efforts that we anticipate undertaking in the next 1 year and 2.5 weeks. So the council is specifically required to adopt rules of court. We anticipate that these rules of court, it's going to be necessary to do them on an expedited manner. We anticipate bringing rules before the court, or before the council, excuse me, in the coming year, probably a set in March, and then hopefully a set again in July or May. Many of those rules are going to inform some of the work at the local level, and so in addition to the fact that they have to be ready to go by that October 1, 2019 implementation date, some of the efforts at the state level are going to inform some of the work at the local level. So the topics of the rules of court include things like the proper use of a risk assessment information, validation of that risk assessment tool, and as Judge Couzens mentioned, identifying and mitigating implicit bias that might exist in the tools, and then also standards for review, release, and detention. The rules are going to make their way through the Criminal Law Advisory Committee and then come before the council. The council is also responsible for compiling and maintaining a list of pretrial risk assessment tools. The trial courts, in consultation with pretrial assessment services, are going to choose from that list of tools that the council maintains. Additionally, the chief is required to appoint a panel of subject matter experts and judicial officers who will designate risk levels for particular tools. And one of those panel members has to include a person with expertise on the potential of implicit bias in those risk assessment tools. There'll be a significant amount of judicial training that was also required in the legislation. CJUR will take the vast majority of that work. They're going to incorporate it into some of the existing curriculum that they have right now. They'll offer live courses, videos and online courses. There'll be webinars, there will be podcasts, bench books, and job aids. So much of the usual work that CJUR does, they will incorporate a lot of this effort around SB 10 and the implementation of pretrial reform into that effort. There will be regional meetings. The JCC is required to work with the Chief Probation Officers of California on regional trainings. We anticipate that there will be 4 trainings in the late winter or early spring, where we will bring together judicial officers, chief probation officers, and other local justice system partners to discuss the new law, work through implementation challenges, try to help foster county implementation plans in counties where they could use the additional support if they're requested, and then also just provide an opportunity to exchange best practices. Many courts and other justice system partners have existing pretrial assessment programs right now, and so it's a matter of providing a forum to exchange some of that information that's already out there. Additionally, the council is required to collect data from pretrial assessment services and the trial courts on an ongoing basis about the implementation of the tool. So some of those data elements are specifically outlined in the legislation. Others might be identified through a process that might be necessary to include to get a better sense of how it is that SB 10 is up and running once the law goes into effect, and so that's another responsibility. Additionally, we're required to submit annual reports to the legislature once the law is up and running, and so that's another responsibility of the council. Another responsibility is the whole allocation of funds. So the funds for pretrial assessment services to the trial courts, there'll be funding that will go to the courts for the work that the courts do, funding that will go to the courts to contract with local pretrial assessment services agency to do the work that they do, and then also funding that will be made available for supervision of individuals who are released pretrial. The funds are going to be allocated through the Judicial Council process after consultation with stakeholders, including the Chief Probation Officers of California and employee representatives. That's specifically included in the legislation. As has been mentioned, there is $15 million in this existing current year for implementation costs. Some of those funds will be made available to the Chief Probation Officers of California. Other funds will be made available to the courts for the work that they do. We'll need funding for the development of protocols and rules of court, technology infrastructure. Because of the timelines that Judge Couzens mentioned, there will be information that will be moving quickly from pretrial assessment services to the courts, the booking agency, so there will be a requirement of some technology infrastructure, and then also training, administrative activities, and other necessary activities to get the legislation up and running. Trial support generally, we are available to assist the development of local rules of court if that's requested, providing sample contracts for courts to enter into contracts with pretrial assessment services who will be conducting those risk assessments. We'll be providing regular updates to trial court leadership as it's requested, and of course to all of you. There's legal training and technical assistance. We're in the process now of developing a web page that we'll make public, hopefully in the next week or so, that will include information related to the related to the implementation of the law, as long as FAQs, infographics to show the actual process of the release and detention decision making, and then that's where we will also house our future reports to the legislature. We are working very, very carefully and very closely with other local justice system partners as the legislation rolls out, and those conversations will continue. We're also soliciting input and working with the sponsors of the legislation in the development of the rules of court and all of the other work that we will be doing at the council staff level. We'll be having conversations with the Chief Probation Officers of California, the State Sheriff's Association, the Public Defenders Association, and the District Attorneys Association in order to be as smooth as we possibly can be in the rollout of this law. Many of the responsibilities rest with the trial courts in this new law, and it is imperative that we're working carefully and closely with these other justice system partners who also have important responsibilities in order to ensure that the legislation rolls out as smoothly as possible. So I think that's it for my update. Thank you.
Any questions? Yes, Judge Hott.
Did I understand you to indicate that pretrial services, gathering the information, and then possibly supervising folks who have some level of supervision is going to be funded through the courts as opposed to, say, county probation?
Yeah, so the way that the legislation is structured is there are three separate pots of money. One is money that will be going directly from the council to the trial courts for the work related specifically for the trial courts. Another pot of money will go to the trial courts that the trial courts will use to contract with pretrial assessment services in counties, which will be probation departments. And so that money will flow from the courts to probation. And then the third pot of money will be made available to probation departments for supervision of individuals who are subject to supervision. And those dollars will go directly from the Department of Finance to county probation departments.
Yes. Judge Botke.
So, first of all, thank you, everyone, for getting this done. You know, as a judge that has these arraignments, you know, several times a week, having a framework to be able to deal with this is certainly fantastic. My question is, if you're a county that has, for example, a consent decree, your jail is full, you have 1381 prisoners, you have people that are back on remand with remitters, you have classification issues between different gangs, you have medical housing, PC, whatever it may be. The sheriff has the ability to release people, triaging basically who stays and who goes. Wherein this just kind of jumps right in the middle of that. Was that something that was discussed regarding those counties that have full jails where this is going to have to be looked at in light of all of those other circumstances when you are at capacity plus 200 people on electronic monitor, for example?
We didn't separately talk about that issue. My reaction to it is that the feds will trump us every time on those issues, and because of that, the sheriff has to honor the federal consent decree. But to the extent that this legislation can be put into play, it will govern in all other situations. I just don't have an answer to that, Todd.
I mean, I guess my question, Judge Couzens, would be this. Let's take the federal consent decree issue out of it, and I don't want to get too far down into this, but if you had a jail that was full and you have someone that under the criteria has FTA'd 4 times in a year, but you have sentenced prisoners, PRCS people that have to stay in, parolees, whatever, that have been at abscon for 2 years, will the sheriff still have the discretion to go above and beyond this, aside from the list of not the non-non-nons, but the yes, yes, yeses?
I'm thinking so, yes.
Okay.
And if I could add something, we actually did talk very extensively about this in our pretrial detention work group. We spent a lot of time because we recognize that jails have this issue. And even in our report, we referred to this. And what we believe, based on the information that we accumulated and the research that's been done, that a lot more people are ultimately going to get out under this. And so the people who are in are the people that are the most serious, the ones that we're most concerned about for public safety and return to court. And so while initially there might be a slight uptick because you have those first 3 days for those medium and high-risk people, ultimately, we think it's going to balance out, and jails are, we believe, if the models that we've seen work, then we'll have less people in jail, and they'll be able to better manage their population so they can keep in who we think as judges should be in.
Okay. Thank you.
Judge Gordon.
Very quick, and to answer to one of the components, as Judge Couzens described, you have that low, high, and medium. And in the medium, we talked about the development of local rules with the county partners, and one of the reasons that was put in there was for exactly that response, because the conditions in all our counties are so different that it allowed that kind of allowed that buffer room to account for some of that.
Can I add to the answer?
Please do.
I wanted to add to the answer, and it's consistent with all of the answers that you've already heard, but just maybe couched in a different way. The truth is, right, the systems will have to level themselves out as you go forward, because you'll have the competing orders related to population caps that are extant and exist, but then you have a change that you're going to implement, and then that will have some effect of populations. And the truth is, for lack of a better term, that will have to thread its way through, because you may find that you're better off operating under that cap that's imposed on you. You may feel like you have a problem. But in managing the cap, we all know that sheriffs have some kind of scheme already by which it is that they're doing it. And sometimes it may be very sophisticated, and sometimes it may be as simple as, today, everybody below 20,000, I got to get you out, right? Because everybody above 20,000, you're staying. Well, next month it's 25,000, then it's 15,000, because we are always using the money associated with the charge as a proxy, sometimes for risk, which we've all learned is not a good proxy. And so the effect at the end of the day is, however it threads, the system ought to be better off and it ought to be smarter from a population management perspective. Again, we'll see what the models shake out, but the truth is, as we go through it, the proof will be there. But to answer your question, which is a great question, and we were talking about it at the state level in the associations that we all described early on, is how will these two things work in parallel? Because they certainly will exist. But then more importantly, how is the interplay and how does it work out as we go forward? It is something for us to manage over the years.
Judge Bulwer-Uri.
Thank you. It might be a bit premature, but the piece relative to identifying and mitigating the bias in the tools, I think there's a fair amount of discussion around the nation about how you identify that, whether it exists. So again, I appreciate it might be premature, but are there any thoughts about how we will be guided, how the team, the group, the persons responsible for that will do that?
So one of the requirements in the law is that the chief will convene a panel of experts, and one of the panels has to specifically have expertise on that very issue. And so, and thankfully, there has been some literature to date on that, and I think you're right, Warren, as the conversation has grown nationally, so have studies, and so we will be looking very carefully at that issue. And that was something when we had some of the experts come and speak to PDR, they specifically addressed that issue and ways to look at how bias might play a role in these tools.
Thank you.
Judge Back, who's here, retired, but co-chair of our PDR group. Welcome.
Morning, Chief,
Morning.
Council. I'd like to start off by saying that you really look good. That's kind of natural. I apologize for being late. I got Dick's, I got Shelley's, I missed the beginning of Judge Rodriguez's presentation. And I apologize for not bringing cigars, because the reason I was late is, yes, there was another grandchild. But I don't know if we can convey how satisfying it was to work on this work group. What is being done here is socially, morally, dare I say economically and legally the right thing to do. I mean, we were not all of the same mind when we came together on this work group. In fact, we were very disparate in our positions, but we came to the same mind as we heard from, 40, 50, 60 people. We became educated. And I think what's important, not everybody obviously is in favor of what's going on here, and there are some criticisms of some of the components, and come on, that's what we deal with all the time, is the details on things. But I think what's important to realize is permeating everything is public safety. Now, I think the impetus nationwide for this is probably we should not be detaining people who are not at risk of reoffending, not at risk of not showing up for court simply because they can't post bail. That's a pretty good impetus. But the public safety aspect of that is not necessarily recognized all the time. It's really easy for the serious folks, these serious crimes. Why the heck do we have to set bail, to keep this person away from doing harm to the public? That person should simply be detained, depending on where they fall in the risk assessment. But for the people who simply can't afford bail, we all know what happens. They lose their jobs. They lose their families. CPS becomes involved. That's a public safety issue. Because if you lose your job, maybe your name is Jean-Paul Valjean, right? You got to eat. And so if you don't have any ability to make money simply because you couldn't post bail to get out to keep that job, you may have to resort to crime. You may have to resort to things that you wouldn't normally resort to. You would have to be in a situation where maybe the health system is impacted because of what's happened, because you've been incarcerated for a period of time when you shouldn't have been. So public safety really permeates everything here. And also, socially, it's the right thing to do. Morally, it's the right thing to do. Economically, for that just little example I gave, it's the right thing to do. And legally, it's the right thing to do. We're judges. I'm still a judge, I think. And so I know some of the concerns are, well, there's too much too much power being given to the judge to make the decision. Hey, this is what we do. We should be looking ourselves in the mirror every day, slapping ourselves and saying, you know what, I'm a judge. I've got an incredible amount of power. I have to remember that, and I have to remember not to abuse it. This is what we do. This is where it should be vested, with the judge making these decisions. So having these guys are amazing. And the people on the work group were amazing. And I think that Lisa can kind of confirm, and my brother over there can kind of confirm. Everybody, when we got to the end of this, felt this was something in our careers that really stands at the top of something we have done, because it's something that's so good for the people of the state of California. Great to see everybody. You guys look really good. Thanks.
Thank you, Judge Bat. You know, I want to say too, what sometimes is forgotten is that when we named this group, we had no idea what the outcome would be. It was study and make recommendations. No preconceived notion about how we should get here or what the result should be or how. And the purpose of a disparate group was on purpose. We needed people to really bring critical eyes to it. And so I think for one, I don't know that I speak for everyone, was surprised to see the unanimous recommendation. I know the stakeholders at large were surprised to see the recommendations being unanimous. I'll also say, as many of you know, this legislature has taken a run at bail many, many times before. But it was only, in my view, until this report came out that was inclusive and conclusive that we actually saw change afoot. And in that regard, it's also important, I think, to notice, notwithstanding the substantial merit of what we are discussing today in SB 10, is that we saw three branches of government working together. We saw three branches of government sharing our concerns and actually being able to have input into a law, and other than afterward, when we have a number of Court of Appeal decisions that have to tell us what the law means. And so this has been an incredible process for government and for our branch to be able to do the research that provided the foundation for SB 10. And so I have a great deal of thanks to all of you, as you know. But of course, as you said here, the road ahead is long and winding. And we have many, many responsibilities and requirements now, not only for trial courts and our stakeholders, our justice system partners, but also now, you know, for the Judicial Council. If you thought, what are we going to be doing for the next 3 years? Now you know. And the beauty of it is we're all here at the inception together and with our experts. And the question, though, is how do we go forward now? And I have decided that based on our time-trusted model of efficiency, and because we have so much else going on in the branch, and every advisory committee already has a full agenda that's already been approved by E&P that fulfills many, many needs, that I'm going to appoint an independent implementation work group, much like we did with language access and the recommendations from the task force, forming an implementation work group that will be a clearinghouse, that will be a place where all issues, all stakeholders, all ideas come and are heard through this implementation work group that would report back to the Judicial Council about the progress being made and the efforts needed and the action we need to take, and giving us, I hope, a full feedback of what we're hearing, what are the concerns, how can we make this law better, how can we ensure, as Dick and as Judge Couzens and Judge Bulwer, you've indicated, that we are on the watch for the concern about implicit bias. And so I'll be announcing that work group later. And I also wanted to say, before we started our second agenda item, because this is discussion only, that I thank, of course, all of you for the comprehensive overview. And there is an award by the Chief Justice that I've only given out 4 other times in 8 years. It's the Chief Justice's Award for Exemplary Service and Leadership. And we have talked about it in the past, haven't used it in quite a long time, but I really believe it's based on what Brian, I completely agree with what Judge Back has said here, that this work that was done is groundbreaking and changes things for so many people and families and futures. That it's my honor to award this Exemplary Service Award to the Pretrial Detention Reform Work Group. And I'd like to name all of you because you've done a lot of work, and for only 11 people, honestly, with the wonderful support of Shelley and her team, and Eve, who's here as well. So I want to indicate that these are the recipients. Judge Brian Back from the Superior Court of Ventura County, Judge Mark Bosenecker, Superior Court of Napa County, Mr. Alex Calvo, Court Executive Officer, Superior Court of Santa Cruz County, Judge Arturo Castro, Superior Court of Alameda County, Judge Hillary Chittick, Superior Court of Fresno County, Judge Richard Couzens, retired from the Superior Court of Placer County, Judge George Eskin, retired from the Superior Court of Santa Barbara County, Judge Scott Gordon, Superior Court of Los Angeles County, Presiding Judge Terry Jackson, Superior Court of San Francisco County, Judge Brian McCabe, Superior Court of Merced County, Judge Serena Murillo, Superior Court of Los Angeles County, Judge Risa Jones Pichon, Superior Court of Santa Clara County, and Judge Lisa Rodriquez, Superior Court of San Diego County. The diversity of those counties speak for themselves. Thank you again. We look forward to working and continuing to learn from your guidance and from your memos, Judge Couzens. So thank you very much.